Welcome back to Elise Explains IP, where we break down the latest and most interesting developments in intellectual property law. I'm your host, Elise, and today we're diving into a topic that sits at the intersection of retail strategy, consumer culture, and IP protection: dupes, or lookalike products. This episode goes out to @Jasper6181, who asked, why does Aldi sell dupes of every product in Coles and Woolies? So, let's talk about it. In particular, we'll be looking at how the budget supermarket giant Aldi finds itself in the middle of high-stakes legal battles around its copycat packaging and branding, both a case in Australia and in the United Kingdom. This is tried before, and Aldi is usually successful, but these cases were different. Before we get into those legal cases, let's clarify what we mean by a dupe. In an IP and consumer context, a dupe is a product that mimics the visual appearance, packaging, or aesthetic of a well-known branded product, but is sold at a lower price. Dupes often do not use identical trademarks or brand names, but they borrow visual cues or design elements that consumers recognise, which raises complex IP questions about trade dress, copyright, and unfair competition. If you want to hear another story about trade dress, check out my episode about the Kraft peanut butter jar. Aldi, with its infamous or famous approach to branding, colloquially summarised by its historic slogan, "Like brands, only cheaper," has become one of the most mentioned retailers in discussion about dupes. But it's not just Aldi. Dupes are increasingly common through online retailers, in cosmetics, and good old Chinese resellers. Often the products may even be the exact same product, made in the exact same factory, just with a slightly different label. But let's get back to Aldi. Their strategy of cutting close to the wind has led to multiple legal challenges around the world. Often, Aldi has been successful because there's no trademark infringement, but our first case takes us to Australia in December 2024, when the Federal Court of Australia delivered a noteworthy decision in Hampden Holdings IP Proprietary Limited and Aldi Foods Proprietary Limited, which involved a children's snack packaging. In this case, Hampden Holdings, which is an intellectual property holding company, and Lacorium Health Australia Proprietary Limited sued Aldi over packaging designs used for its Mamiya branded children's snack products. Their competing product, Bellies, included Baby Bellies, Little Bellies, and Mighty Bellies ranges, and it had packaging artwork that included a distinctive layout and design elements, and a particularly unique character that was on the packaging. Documentary evidence in the case showed that Aldi instructed its designers to benchmark its packaging on the Bellies brand, effectively using it as a template. The federal court found that copyright had been infringed because Aldi's packaging reproduced a substantial part of the artistic works used in the Bellies packaging. Infringement was established qualitatively, not just by counting visual similarities, but by assessing whether the copied elements amounted to a substantial part of the original works. The court also awarded additional damages, emphasising that the copying was flagrant and had been done for commercial gain, particularly given the evidence Aldi continued selling the packaging after legal demands had been made. This is not always a bad sign, but it can get you in trouble later. The decision highlights that copyright in packaging designs, particularly original artistic works such as layouts, fonts, characters, and composition, can be a powerful tool to protect against lookalikes, even when there's no allegation of consumer confusion. This is significant because trademark and passing off claims against Aldi have often failed in Australia. Historically, courts have been reluctant to find confusion or deception where consumers know that they're not buying the original, that they're buying an Aldi product, even if the packaging looks similar. So now let's turn to the United Kingdom, where a major trademark case similarly put lookalikes under the microscope. So this is Thatchers Cider Company Limited and Aldi Stores Limited. After several rounds of litigation, the UK Court of Appeal delivered a pivotal judgment in January 2025. So, for a bit of background context, Thatchers is a family-run cider producer, developed and they have heavily promoted their cloudy lemon cider product. They have a registered distinctive trademark covering their packaging and branding. Aldi launched a competing cider under its Taurus brand, with packaging that, according to Thatchers and the case, bore significant similarities to its registered trademark. So in the first instance at the Intellectual Property Enterprise Court, Aldi succeeded. The judge found that there was low overall similarity and no unfair advantage. But on appeal, the story changed. The Court of Appeal held that the Aldi packaging too closely resembled Thatcher's registered trademark and that the resemblance cannot be coincidental. Crucially, the court found that Aldi intended for its packaging to remind consumers of the Thatchers product, conveying that its Aldi cider was like the Thatchers product, but cheaper. That whole benchmarking thing again. This behaviour, the court concluded, meant Aldi took unfair advantage of the reputation of Thatcher's trademark in breach of Section 10(3) of the UK Trademarks Act 1994. So the take-home message here is that even in the absence of direct confusion about the origin, a competitor can infringe a trademark by taking unfair advantage of another brand's reputation, at least in the UK. The ruling emphasises how courts can assess a parasitic intent. It was one of the first cases that went with this bad actor sort of vibe. Leveraging other brands' marketing and investment, and is a distinct form of trademark infringement. So Aldi had sought permission to appeal this decision to the UK Supreme Court, but as of June 2025, that permission was refused. So what broader lessons can we draw from these two particular cases? The first is that legal tools are beyond trademarks. The Australian case underscores the importance of copyright protection for packaging designs, particularly where the aesthetic expression is distinctive and can be protected as an original piece of art. As an alternative or to complement a trademark or a registered design strategy. Second, the meaning of benchmarking. Both cases show that while benchmarking, which is using an existing product as a design reference, is common practice, when it crosses the line into substantial reproduction or an unfair advantage, the courts will intervene. 3. Involving enforcement trends. From the UK's focus on unfair advantage in trademark law to Australia's assessment of a substantial part in the copyright, the law continues to adapt to the realities of dupe culture, potentially making it easier for brand owners to enforce their trademark and intellectual property rights against lookalikes. And that's it for today's episode of Elise Explains IP. I hope this gives you a clearer picture of how courts are navigating the fine line between inspiration and infringement in the age of dupes, and why sophisticated intellectual property strategies that include trademarks, copyrights, and design rights matter now more than ever. Thanks for tuning in. If you've enjoyed this episode, please subscribe and leave me a review. Until next time, I'm Elise, explaining intellectual property law in terms that you can use. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.